First of all, Mr. President, as well as the Attorney General of the Federation, for taking that initiative to go to court. And to court through the instrumentality of the office against the state attorneys general. It then enables the Attorney General Federation to invoke the original jurisdiction of the Supreme Court. And once that happens, then there's the likelihood that the matter gets addressed within a very short period of time. If this matter were to go before a federal high court or a state high court, the likelihood is that in the next 5-10 years, the matter is not resolved. And if you have followed the developments that are unfolding, many of the states have raised objections to the original jurisdiction of the Supreme Court in this matter. They're insisting that the matter should go through the entire gamut of coming up from the High Court to the Supreme Court. And you know that takes almost an eternity. But if the Supreme Court comes to the conclusion that this is the right circumstance under which its original jurisdiction can be invoked, then you can be sure that perhaps in a month or less, the Supreme Court would make a definitive pronouncement on the subject. And indeed, regarding the constitutionality of the caretaker committees, the Supreme Court has made that very clear, from Ekiti to Oyo and a number of other states. Where we're likely to have a sticky point is whether, if you have transition committees or caretaker committees, the funds that are due to local governments should not be released to those caretaker committees. That might be one aspect of it. But ultimately, beyond the intervention of the judiciary, is the political solution. And I'm delighted that Mr. President is leading from the front in this respect. And in the American system, there is what is called the power of the bully pulpit. Not necessarily that Mr. President is going to bully the states, but that Mr. President can leverage the power of his office to ensure that he leads from the front to push this agenda forward. That's one political dimension. But the other dimension is to come back to constitutional amendment, as I pointed out yesterday. If you look at the dynamics, at this point, the majority of states are not on board. Now, what do we need to do to get these states on board? Beyond what Mr. President can do, can we look at the dynamics at play? To give you an example, if you look at the last constitutional amendment exercise, the governor of Bauchi State was in office. And I mentioned governor because, as you know, many governors wield considerable influence on their state houses of assembly. He was the governor in office. He has been re-elected. He is the chairman of the PDP Governors Forum. Can he be a partner in this journey to mobilize the governors elected on the platform of the PDP? The governor of Kwara State is the chairman of the Nigerian Governors Forum. In the last constitutional amendment exercise, Kwara State is one of the states that did not make returns to the National Assembly. So we couldn't say at that point what the position of the Kwara State government was. But I read a statement recently credited to the governor, who has also been re-elected, that is for local government autonomy. So can we get the governor of Kwara State to mobilize his colleagues? If you look at the governor of Imo State, he is the governor of the he is the chairman of the Progressive Governors Forum. And the last exercise, Imo State voted for administrative autonomy. I'm not sure either administrative autonomy or financial autonomy, but didn't vote for the other. Now, can we get him to mobilize his colleagues? At the moment, the chairman of the Conference of Speakers is the Speaker of the Oyo State House of Assembly. Now, if we have a sense of how the Oyo State governor is going to push this agenda forward, then we can be more constructive and strategic in terms of getting them on board.
All right.